Now joined by legal commentator Nthabiseng Dubazane. And Nthabiseng, good morning and thank you very much for your time. You know, let's start with what we just ended off with Lindsay. That section 194 subsection 3, which deals with the powers of the president to suspend. You would have heard in that conversation with the reporter that Dalimpofu had stressed that the powers to suspend were not in question. The president can in fact suspend, but said the president had acted ultra vires insofar as the timing of the suspension of Mkhwebane is concerned. So now, given that this particular committee was established in 2021, according to your view, when would it in fact have commenced? Because the president is empowered to suspend at any point when proceedings get underway. Was it back in 2021 when the committee was established, or it was on the 10th of June when the court ruled that they can in fact continue with the impeachment proceeding?
If we're to deal with the establishment of the institution or the commission itself or the inquiry, it would be in 2021. But the question is that did they actually have work to do at the time, as well as various legal matters that were before various courts that now have given rise to what we're dealing with since yesterday. So I think it is probably a yes on both fronts, that it was established and then it was there and it was ready to function and work since 2021. But now, since yesterday, it is officially has a job to do. Because remember, the process of getting the public protector impeached had not really started. It had been threatened in a manner of speaking, but nothing really had started at the time. But now that the courts had conferred the powers on the committee to actually start, then it means the work can now officially be there. However, it's the question that remains would be, in the time from 2021, were they doing research on their own? Were they gathering more evidence? I think that's why yesterday's conversation is very important, in that most of the adjudicators or the people presiding over the hearing want this to be such an objective hearing, because they want not only the four main disappointments, so to speak, or the negativities laid upon the public protector, but also the things that she has done right in her office. And over and above that, they want the people that she has been working with, because she's not a sole soldier in this situation. She has people working with her in the office, and they want those people to also be placed before the committee, and so it is not a non-biased hearing against the public protector.
So meaning when Advocate Dalimpofu went on to say, I think it was either to Mr. Mulder or another honourable member there, went on to say that, you know, this may seem like plain English, or it may seem simple to you, but to legal scholars or scholars of the Constitution, it is not simple. Interpretation is everything, because just judging by what you're saying, it's either or. It could have commenced, at least the proceedings could have commenced, like you say, back in 2020, or they could have essentially commenced yesterday. So there clearly is some sort of a quagmire here.
That is very correct. I think that's why we have a statute of interpretation, because there's a lot of legalese that is it is within the Constitution. So in us interpreting what is there, the interpretation clauses of the Constitution need to make sense. So we need to understand, when exactly did we start the process? When exactly did work commence? And as a result, it will then map the way forward. I think part of the things that were being argued, for example, were that the fact that it's the public protector that needs to be protected, or it's the office of the public protector that needs to be protected. So that was also another contention, whether or not we're dealing with the person or the institution itself. So those are things that I think that today might need to be dealt with, and things as in the suspension of the public protector, the things pertaining to legal matters that are ongoing as a result, things along the lines of whether or not there are going to be other people presented here, and whether or not we're going to deal with other cases other than the one that are put before the committee today, that are going to be dealt with in order for them to be weighed against each other. So there's a lot of housekeeping, I believe, that needs to be done today.
No, most certainly. But another important or critical question is, does the alleged unprocedural suspension have any bearing on the process that's currently unfolding? And do they even have the powers as Parliament? Because I listened to some of the parliamentarians saying, actually, we cannot. This is beyond our purview. We cannot deal with whether the suspension was procedural or not, what did he act ultra vires or not. So do they have the powers to tackle that particular matter as to when she should have been suspended or not? And does it have any bearing right now on this particular process?
I think they can canvass it as part of the proceedings, but as to whether or not to challenge the suspension, that is a completely different story. As said already, the president, in terms of Section 194, already has those powers to suspend the public protector as and when. So the question of whether he did it prematurely or ultra bonus mores is something that can be canvassed as the proceedings go on. So it can be used probably when at the end of the proceedings. The committee now has to make a decision based on that alone. Should he have waited those 12 or 24 hours and wait for the court to give him the green light, or even the red light had it gone the other way around? Does that affect the manner in which these proceedings will now go on? Does it affect the fact that now she appears as a suspended public protector instead of an active public protector? And what does that mean as a consequence going forward? The powers of the current acting public protector, what do they mean on her current situation? So I believe that one is a matter of it being discussed within the hearing, but I don't believe that they have the kind of powers to try and challenge and have that decision revoked, unless, of course, they bring the president to come and give reasons and set them forth as to why and justify the reasons why he suspended her prior to the court actually giving him the green light.
Mm-hmm. But it seems they're swaying towards the possibility of getting an independent legal opinion on this particular issue. But then what next from here? Once the committee concludes, then we understand that this will be put to the House, to Parliament, and then 2/3 would have to vote. Talk to us about that.
Yes. So once the 2/3 have voted, the ultimate decision is always with the president, who will then take that vote and depending on which way it goes, he can either uphold that vote, the vote being, let's say that she is now officially suspended and being removed in her capacity as the public protector. Then he can make it official and then uphold that, or he can make it a different decision based on whatever evidence that is brought before him after the 2/3 majority has voted, and see that if he goes the other way around, which is basically continue with her being the public protector. So I think we will just have to wait and see how it would then play out, because as it's been said numerous times yesterday, this is uncharted water. So I think we just have to go as we assume the Constitution says, and then how we interpret it to mean going forward.
And Thabiseng, thank you very much for your insights and just helping us make sense of this first of its kind. That's legal commentator and Thabiseng Dubazane.